first question is, what are the barriers within the current system, in your view, that actively get in the way of professionals being able to do the right thing by the young people that they're working with?
I suppose that the first thing that came to mind was that I think we've got consensus so far as our fundamental piece of child welfare legislation, the Children Act, is concerned, that's solid, that's sound, and it's unique that we've got consensus about that. But that framework, our system's not really been designed with extra familial risk in mind. And I think what we've seen over time is sort of a heightened understanding of it, the evolving of best practice and so on. But the fundamentals of our system and our framework haven't really been set up to focus on that. What came to mind then is the work of organisations like PACE, working in the child exploitation space, for example, who talk about how the system doesn't respond in the right way to them, to parents, to what children are experiencing and the battles they have. So I think that's the first barrier, sort of continuing that journey. The next thing that came to mind was, I think, certainly the child welfare system. I anticipate elements also of the youth justice system are very process-driven, very procedural in their responses, and there's characteristics of the current context which I think really exacerbate that. So when you think about individual social work practitioner high workloads, when you think about messages from the Care Crisis Review, for example, about cultures of blame, cultures of shame, concerns about managing risk and so on, what you end up with is people responding in very procedural ways. And I think that remains a barrier. I don't think that's abated. And there's examples that come to mind when we think about the criminalisation of children in residential care, when you think about the sort of the system very often automatically responding to adolescents who become young parents, immediately assuming risk and pushing their children or their unborn children into a child protection space in a way that completely lacks nuance and is rails against our understanding of good assessment and partnership and so on. And then I think the other key barrier that I perceive is that the system pushes everything. Too many systems push response to the acute. So I can think of many examples of older children, acute situations, but when you review the history, when you read those social work chronologies or those court papers, what you see is a long period of pseudo involvement by the state. But if you look between those case closed markers on those chronologies, you see very little by way of actual concrete help. Even if you see assessment, you see very little by way of provision for that child, for that family. And then down the line, what you see is the state trying to respond to a much more acute system where things have really escalated. So I think until we overcome that, I think practitioners are in a really difficult position. Whatever their competence, whatever their commitment, however proactive they seek to be, I see those things as real barriers.
Okay, and you talked about a consensus around the Children Act, but do you think actually is for when adolescents are concerned, maybe there is room for improvement? And do you think that possibly it wasn't such a great idea in retrospect to separate out the child welfare and the youth justice systems in the way that happened? And post-Children Act, actually, really. Well, no, with the introduction of the Children Act, but then with the development of youth justice.
I suppose what I can say is that you can see the lack of connectivity between those two systems. And you see it even though, we have a 2004 Act that emphasises partnership working at local level. So although I've talked about partnership as between state, child and family, there is this interagency partnership working, but we can see these systems don't speak to each other. And I think viewing the Children Act as, a credible and enduring piece of legislation doesn't mean that there isn't scope to improve or add to or address, or that there isn't any weakness. I think we've got a sound bedrock from which to work from.
Okay. And then in terms of your own experience of what happens if you get young people coming into the family justice system, so your experience as a lawyer in terms of the sorts of circumstances in which they may come before the courts as young people, what's your experience of the way the courts and professionals are best able to meet the needs of those young people?
I think the role of the children's solicitor, the role of the children's guardian are really critical in those cases with older children. When those roles are done well, you have a much more dynamic process of really understanding the child's perspective, the child's needs, the child's views and wishes. I think when those relationships aren't so good, or that work isn't done, you have a gaping hole in the proceedings. I think as children get older, my experience is that they're very, how can I put it? As the older the young person, the almost less they are recognised as a child, and as they get older, I suppose that narrative of problem, challenge, sort of, escalates. We've done all we can. My other experience is of seeing children who I'm aware of being in foster care, then seeing them appear in residential care, and then receiving papers to pursue an application for a secure accommodation order, for example. So this trajectory, this sort of sad conveyor belt where suddenly the system says there's nothing more to do, say, ask the court for authority to, lock this child up for a period of time. And I think those secure accommodation proceedings, those applications they're really stark, because the child is at court, the child is in court, often asking desperately not to do, for this to happen. If it's proceeding on the basis of a voluntary arrangement, the parents accepting of the proposal, they won't be legally represented in the proceedings, which is particularly stark given what's at stake. And then my other observation and experience is those plans for secure accommodation arrangements for children, that isn't a long-term, it's not even a medium-term response to meeting the needs of a child and planning for a child. There's supposed to be an exit, there's supposed to be a destination, and very, very often, I would say, in practice, I've seen that just not properly attended to.
And when you talk about two things there, when you say the child is there in court with a legal representative, presumably, were you saying that the parents aren't represented in those proceedings? Or
if the local authority are pursuing an interim care order at the same time, so the child is, because the child needs to be looked after by one mechanism or another for the secure accommodation order to be made. If it's an ICO scenario, then the parent will have legal aid and will be represented. If it's proceeding under a voluntary arrangement, that doesn't kick in.
Mm-hmm. And when you talk about it's a short-term response rather than a proper plan, is that what you've seen? You haven't seen it located within this is a stage one and then we're going to move on to something else? How well are they reviewed? How often do they come back? Those sorts of questions, really.
So, I mean, they're by their nature time-limited plans. But the emphasis, where a child is going into secure arrangement under a secure accommodation order, the emphasis should be on exactly what's being provided during the course of that placement and what will happen thereafter and what is being put in place to enable, the child to leave that setting, and the adequacy of what's going to be put in place next. And my experience is that is obviously a very tricky plan to formulate. there's always some initial uncertainty, because often what is going to be provided in the secure setting is going to be the gateway to putting that next stage plan in place. But my overall impression is that, an experience, is that those next stage plans aren't well formulated. And I think that's partly grounded in the fact there isn't always an awful lot to work with in terms of resources, placement types, and creativity within the local authority.
And do you have experience, or, excuse me, have you heard about because of the shortage of secure accommodation, increasing numbers of children not going down that route, but going down an inherent jurisdiction, deprivation of liberty route, and into unregistered homes? Is that something you experienced, or is it something you're just aware of happening?
Just aware of and tracking, but no, I haven't directly experienced that in practice. But I mean, it's obviously really troubling.
And what troubles you about that as a lawyer?
Well, it's sort of, I think there's a few different things there. If you go back to absolute basics and you're thinking about, paramountcy principle and welfare checklists and so on under the Children Act, the child welfare system's grounded in, identifying need and responding to need, identifying the extent of risk and how you manage that and respond to that. When you hear of children whose, needs are understood to whatever extent, and the response of the state is, a caravan with 2 workers in it, or, an accommodation that's really only suitable for an adult or similar, I think it's really stark that whatever has been identified, whatever's been assessed by way of need, there's nothing in response. There's nothing adequate or appropriate for a child being provided in response. I think the other element is, and again, this is something that I certainly experienced in practice, is not being able to find a form of accommodation that would accept a child because of that child's particular history. I think of cases where there was concern about the child's interest in fire and fires having been started. So every form of residential provision that you approached, it was an immediate no, because it didn't meet their, wouldn't pass their risk assessment. So there's these children with identified needs, with these, really difficult experiences manifesting in a range of behaviours, and effectively the state saying, we don't have anywhere for you.
Yeah, you've also talked about children moving through as they get older, being treated less as children. Do you want to say a little bit more about that, around the way in which society looks at children?
I think it's most stark when the young person while still young, becomes a parent, including when that young person is still in the care system or has left the care system recently. The response of the child welfare system is to reorientate its focus purely on the child's child, as it were, or largely on the child's child. I think that manifests in different ways. It manifests in there being a lack of joined up thinking between the planning for the baby and the plan that is in place for the young parent. So that young parent may have a pathway, should have a pathway plan, for example, already, or one in the penning that will say, what's intended or in place in relation to educational support and accommodation. But it doesn't speak to the reality of them being a young parent, because the focus is on the child protection plan, for example, for the child, and not the relationship between the two. And the needs of that young parent become then, despite being a child, despite being very young themselves, become completely secondary and marginalised. Where in fact, just on a basic whole family assessment premise, you don't disaggregate child from parent. whether the parent's a child themselves or an adult. You look at the round, you respond to the round, you respond to the need of the child in the family, the child and the family.
Thanks. And you also talked about chances missed. If you followed a trajectory through, you could see not enough being offered and done. Do you want to just talk a bit more about that, how that's all working out, given the Act, the Children Act and the 2004 Act talk about support to promote welfare?
So I think in relation to that issue, the problem is not that the legal framework for doing it is not there. The problem is twofold. One is that the reality of what is on offer in a given local area under, for example, a Section 17 child in need framework, as reflected in a local threshold document, may vary significantly and may be very little. So the first element of the problem is need recognised, need assessed, but you don't meet the threshold. You're not, that child and family is not in need enough to be responded to. There's that element. I think the other problem is that the lens of risk comes to bear very firmly on families and children, even at a stage where this is not about child protection concerns. We're talking about family support, or we're talking about early help, but very often everything is seen through the lens of risk, and therefore if it doesn't feel like a risk situation, if it doesn't feel like a child protection scenario, nothing happens. So again, little response. And the corollary of all of that, whatever the particular driver, whatever the particular circumstances in the case, is that at the point at which a family starts to struggle, or a child is struggling, or they need some support, it may not be there. If it comes, it might not be what they need, particularly as often families and children aren't asked what it is they think they need. And if something is put in place, often it's late. And by which point, as I think I said earlier, things may have started to escalate. The frustration with the system may be growing on the part of the family. We've been asking for help and we're not getting it. I think there's often this sort of perception that families and young people are hard to reach. But my professional experience is that actually most often they're crying out for help, whether overtly, or more implicitly, but they absolutely are. And what's hard to reach is the actual support.
Mm-hmm. Yeah, thanks. If thinking now about the sort of positives in the system, if we were to think about what's worth keeping, what does work at the moment, do you think? What's worth keeping, holding on to in our current system?
So I think it's definitely worth holding on to that. Various statutory guidance recognise the role of family-led decision-making, the role of bringing family together to formulate plans to keep children safe. I think there is, that's reflected in statutory guidance, but I think it's underutilised, certainly in the youth justice space. I was talking to a colleague earlier today who was saying in New Zealand, half of all FGCs occur in a youth justice context. I don't think that's true here. But FGCs have a whole range of, uses and applications. And so I think it's hugely positive that we have that, and that we absolutely want to retain that and grow that focus on family-led decision-making and its use at lots of different junctures, including when children are in the care system and are leaving, as well as when we're looking at whether children need to come into the care system. So that would be the first. I think it's very important we retain the prioritisation of placement with families that's reflected in the Children Act in Section 22C. There's a reason that's there, and I think it's really crucial that practice recognises that a young person in the care system is still a young person for whom exploring the family and friends network is really important. And whether you're doing that because you're thinking about who will be there to perhaps catch them and support them when they leave care, or who is just generally going to be in their corner, or whether you're looking at return home, or return to the family. Whatever the emphasis, that prioritisation is really important. And then I think the underlying principles of the Children Act around partnership, the emphasis on partnership working across organisations and agencies in the 2004 Act are all positive things. I mean, I think that framework is solid and those principles are solid. It's the response to them and the operationalisation of them that's a real problem.
Mm-hmm. Thanks, that's helpful. Thinking a bit about family decision making, family group conferencing that you've talked about. Do you feel that that is sufficiently used for adolescents currently, or is it something, where do you think it's most used currently and where could it be better used?
I think it's probably most used in the context of anticipated court proceedings in the guise of care proceedings in the family court. I think there's certainly evidence of local authorities using them much earlier, but again in a child protection context. I think we see less of its use in relation to older children, which I think is a real shame for many reasons, but not least because the child's participation in an FGC is absolutely embedded in the idea of FGCs and the support of an advocate and so on, and the child's direct involvement, where appropriate in the process. So it seems to me that, an adolescent is absolutely a young person who should be offered an FGC, for whom an FGC could serve a number of purposes and have a really pivotal role in planning for them.
You also talked about the important principles of placement with family, links with family, contact with family. Do you feel enough is done to enable young people who do come into the care system to maintain those links?
Well, I think we're all really aware of the messages from the care inquiry about what the care system does in terms of breaking relationships rather than preserving and developing them. And I think we all hear these messages again and again about the importance of relationship-based practice and the importance of relationships for young people. And I think we all know that in practice, too often those just aren't prioritised. But there are mechanisms to do that, and there are ways to do that. And I think the lifelong links work that FRG does, looking at trying to, identify those lost connections, those important connections for children, and working with children and to identify them and deeply search for those connections, shows that there are ways of doing it. There are models for doing this, and these things should be a priority for young people in care and for people leaving care.
Do you think there is an issue in the way in which we've talked about this, you were talking about this, shifting, if a young person becomes pregnant, then the focus is on the baby. But do you think generally we have difficulty in this currently, sort of really accepting that young people are children in the sense of the legislation, but also so taking account of that, but then also allowing them some sort of developmental opportunities to make their own decisions? So I'm thinking of legal ages for, consent, but compared to, say, the age of criminal responsibility, those kinds of areas. What's your view about sort of legal framework in those respects?
I think we've got quite a mishmash of a framework here. We have different ages for different things. We have different sort of understandings of competence in different contexts. And I think there is also quite a stark variation in practitioner comfort in relation to sort of child participation and child decision making. And when I say practitioner, I'm thinking about family lawyers as well as social work practitioners. And at a sort of supranational level, we've got a UN Convention on the Rights of the Child, which absolutely, foregrounds and protects in respect of children's participation and their views and so on. And I think, I don't know, we definitely struggle with it. I don't know if we struggle with it in a pure legal sense, but certainly those working within the system struggle with it. I think local authorities struggle with it.
And you've mentioned the United Nations Convention on the Rights of the Child. Do you have a view about how well attention is paid to that within our English and Welsh legislative framework?
I think it's one of those things that people often mention because they think they must mention it. And what you don't see is a sort of, certainly in England, a real adherence to it. I think certainly it's really been the higher courts, the appeal courts, where if you see decisions about children's lives, about family lives made, there are certain judges who have been very good at both explaining and applying the convention to those decisions in respect of immigration decisions and in respect of child welfare decisions. I don't see that trickle-down effect routinely in our family courts, for example. I don't see that rigorous children's rights analysis in your average family court judgment.
What do you think might encourage a more rigorous consideration of those issues?
I think advocates need to make their representations and their submissions with proper reference to the human rights framework, more detailed reference to the human rights framework, both the Convention and the European Convention. I think some authorities have or did have children's rights officers. I don't know how far that is the case anymore. Local authorities should really audit their policies with reference to the Convention and human rights.
Mm-hmm. What about Wales? Do you think there's a distinction there with Wales?
I mean, there is a distinction. It's interesting that you have the sort of one approach in England, greater progress in Wales, and then you have the direct sort of incorporation in Scotland. So it's sort of it's representative of these three different tiers of approach. You certainly see in the Welsh legislation, reflected through the Welsh legislation and also through the specific mechanisms and requirements to have regard to the Convention and so on. Greater awareness and understanding, I would say, of children's rights. And that it feels both tonally different and different in practice, I would say. But I'm not a Welsh-based practitioner, of course.
Yeah, thanks. Just moving on to thinking about, well, those are the main things you think we should keep, which is family group decision making, working in partnership, contact, basics around contact and family placements. What about things like, I know that you have responsibility for within FRG of issues around kinship care, where you may have young people actually taking on responsibility for younger siblings. Do you think there are issues around there that either are good that should be kept or that could be dealt with better than they are now?
I think we hear of siblings being given real misinformation about their options in relation to wanting to be assessed as potential carers for their younger siblings, and also about the legal frameworks that apply. I can think of examples of an older sibling being told they couldn't be a special guardian, that it was an impossibility. I think there's also a challenge for particularly where the prospective sibling carer has themselves been in the care system and they're a care leaver, and they are still looking for support from their corporate parent in their capacity as a young person having left the care system. And now they're looking to that same local authority, that same agency for support in relation to becoming a kinship carer and for caring for their siblings. And again, I think quite often the child welfare system is fine up to the, can operate okay up to the point where things feel messy and complicated and there's overlapping duties owed to people. And I think that's one such example. I think we also feel the loss of some of the organisations that used to operate in this sort of sibling space that we don't have so much. And I think there's not a huge amount of policy attention on that sibling kinship care scenario.
Mm-hmm. Okay. What about in terms of your thoughts about how a vision for the future for young people and a world and a framework, a family justice framework, beyond, and a welfare framework that would lead to a better options?
Yeah. I think the starting point would probably be partnership and relationships, that those absolute fundamentals are understood and lived out in the system, because from my perspective, everything else flows from that, assuming your legal framework is sufficient and in whatever regard sufficiently flexible. But if we don't crack that, I don't think we'll have the kind of progress that we hope for. So my vision would be certainly for a real understanding at practitioner level and at agency level of what relationship-based practice looks like, and about what partnership working in whatever system looks like. So that would be the first limb. Would like to see much stronger emphasis on drawing on the learning from other authorities, from other organisations, from the voluntary sector, about how you do that, about be it the application of FGCs and lifelong links, or about particular services that have worked well for young people within local authorities or within the family justice system. And I think ultimately that we don't we don't churn out, we don't push out of either the local authority or out of the youth justice system and see young people going it alone, because those things I've talked about have not been prioritised or properly attended to. Because then what you have in society is then a group of vulnerable young adults.
Thank you. That's helpful. Do you want to say a little bit more about how you see relationship-based practice working? And particularly, I suppose, not only, whether it can work, can you see something like that happening within a court system as well as within a child welfare system?
Well, I think we've got evidence of what sort of problem-solving models of court look like, what a more sort of exploratory court process looks like, as opposed to one that is rigid and responds in a rigid way and isn't problem-solving in its emphasis, is processing rather than problem-solving. And I think I don't think we always learn from across sectors. So this is an interesting discussion, because you're trying to get me to talk about child welfare, family justice and youth justice in a connected way and in a relational way, which makes entire sense, because we're often not talking about different groups of children and different families experiencing and touching on these systems. We're often talking about exactly the same family coming into contact with this whole range of agencies, practitioners and systems. Can you repeat the question, Mary? I just bring my thoughts back.
I was just wondering about whether you had some sort of specifics on relationship-based practice, what that means to you, really. So, yeah.
So to me, it means you have to have more time spent with families, with children, by that individual practitioner or small group of practitioners. You don't build trust, you don't build relationships where you are working in a climate of multiple changes of practitioner and high caseloads. It just seems to me something that isn't achievable. So that's the first limb, some measure of consistency and a measure of proportionality in the workload that people have. I think the other element of relationship-based practice is sort of permission for practitioners to not only spend the time, but to do that kind of problem-solving work with families where you've got a much more reciprocal relationship. What do you think you need? What would help? Talking, family members talking to people that they trust. We often give advice to say, you know, if you're struggling to think what would help, talk to best friend who knows what you've been through, knows what you're struggling with. What does she or he think from the outside looking in, but close to you would help? And I think practitioners need to be able to tap into that, to have those conversations. And families and young people need to know really clearly what's expected of them and what they can expect of services, agencies and individuals. That's part of a relationship. This is what you can expect from me, and this is what I expect from you.
Thank you. It's very helpful.
So my response would be that the text of the legislation is the threshold. This, Section 17 says, a child in need, health and development, so on, can extend to the family. To me, that's your threshold. That's what we should be measuring against. Those other thresholds are, they're constructs. They're a way of managing resources. They're a way of, and I would probably be criticised for saying that, because I would be told that, they're part of discerning who needs what and who should get what. But really, those threshold documents read child in need, for example, about who is in need enough to get help. So it's not about whether or not the child is in need. It's in this area. This is what we've got on offer, and you're not in need enough to get it, unfortunately. That's the sort of crude analysis of it. So, and there are examples, for example, in Leeds back in the day, where what they did was get rid of thresholds for teachers and other agencies making referrals, and those referrals being made, get rid of other kinds of thresholds, seeing them as these layers on top of a system, and a primary piece of legislation that said, child in need, that's what this means. Identify the children in your area. Your duty is to identify the children in your area who meet that definition, not to thereafter filter out assistance to them. But the reality is resource. It's a response to resource allocation, I would say. Love to see something stronger. It's been a campaigning point, well, I suppose two things. One is, if you can enshrine as a right in primary legislation these additional things, then yes, why not? And that would be, beneficial. But anything short of that, additions to statutory guidance, one, important, because if it is at least in statutory guidance, families have a basis on which to challenge if they need to. But we do have to confront the reality that we have a real issue with adherence to statutory guidance, because it's not followed. Whether you're looking at particularly family and friends care statutory guidance, to take but one example. So I suppose the corollary of that, of what I'm saying, is we can add to the system, but anything that falls short of a, primary duty on legislation, I think is going to be problematic. And we also know that, agencies don't always follow their primary duties either. But we have to remain hopeful, otherwise we wouldn't get up of a morning.